Welcome back to another session of Legal Essentials for Human Resource Management. Now, this is week 7, session 31. And if you remember our discussions till now, we were looking at various industrial dispute resolution mechanisms. In the last session, we had looked at the evolution of various dispute resolution mechanisms in the country when it comes to, especially when it comes to industrial disputes. We had looked at the constitution of works committee, how it is formed, what is its purpose, what is its role at workplace, as well as conciliation officer and conciliation board. Let's move ahead into discussing some other dispute resolution mechanisms, which are tribunals, labor courts also we'll discuss, as well as the changes that has been brought in the newly proposed IR code. So without much ado, let's get into the detailed discussion of topics, industrial tribunals, as well as changes that is brought in by IR code in the entire industrial dispute resolution landscape. I hope you know my name by now. My name is Dr. Amish Samilopanan, and I am from Nalsa University of Law, Hyderabad. Now, one of the mechanisms that was there in the Industrial Dispute Act, it is very rarely used and hardly used is the word, and has been replaced in the IR code, is courts of inquiry. Now, what is courts of inquiry? It was a typical body that was a tripartite body which was set up by appropriate government and had one independent chairman, two or more members with equal representation of employers and workmen, and they coming together became court of inquiry. Now, the whole purpose of court of inquiry was to conduct an inquiry into disputes and report on facts and circumstances, and not to mediate or settle disputes. So these courts of inquiries often acted as investigative agency of the appropriate government to go and understand the various facts and circumstances that led to the dispute. They didn't have any mandate to resolve the dispute. So, needless to say, it is. See, the whole purpose of industrial dispute redressal mechanisms is to come to an amicable solution at the earliest. So, the court of inquiry didn't have that mandate, and it has been now repealed in the IR code. In IR code, you will not find a equivalent section of a section 6 of IDA Act. Now then there are labor courts, industrial tribunals, and national tribunals. Now, this was another mechanism that is proposed in IDA Act, which is Industrial Dispute Act. So let's say conciliation fails. I told you conciliation is a success. The results are the verdict or the decision made is binding. Report is submitted to the government. Well, what if the conciliation fails? Now here, the disputes may be referred to adjudication. So it goes to labor courts or tribunals. So there was more like a 3-tier system of adjudication, which included labor code, industrial tribunals, and national industrial tribunals. Now all these sections are Industrial Dispute Act sections. When the IR code would be officially implemented, these sections may not hold much relevance, and you might have to fall back upon IR code. But that's the case, labor code may not be there, so there no longer be a three-tier system. What happens if an IR code comes into an applicability? We'll discuss going forward. So, Section 7 provides for the constitution of an industrial tribunal, which could be a single member or a multi-member body, to adjudicate disputes referred to them. So, presiding officers would normally be a person eligible to be a high court judge, would head the tribunal. So, this labor court. Now, there is an industrial tribunal and a national industrial tribunal. And for the tribunals, it would normally be a person eligible to be a high court judge. Now, in 1956, the Section 7 was brought in new sections, with Section 7A and 7B was added, which converted this entire mechanism into a three-tier adjudication system. So, labor code are one-person courts for adjudication of disputes relating to matters like disciplinary actions, application and interpretation of standing orders, illegal strikes and lockouts. So it was your regular court, like one-person court, and essentially for disputes regarding to your rights and or less complex issues often mentioned in the second schedule of Industrial Dispute Act. Often they used to deal with individual or smaller dispute, like dismissals. If you remember, we had discussed this in before. It can be a industrial dispute if it is regarding only one person also, but it has to related to termination of his employment. So such all disputes can go to labor courts. And then there is industrial tribunal. Now these are one-person bodies again, but but it changes in industrial relations code. I'll discuss that. But as in IDA Act, it is a one-person body to adjudicate disputes on any matters which is discussed or which is under the purview of a labor court, as well as a broader disputes like wage. So that's a broader dispute that considers all the workers. So wage, allowances, hours of work, leave, bonus, profit sharing, retrenchment, closure, etc. So second schedule includes various matters that can be dealt with labor code. Third schedule discusses with matters that can deal with matters that industrial tribunals deal with. And one differentiation is that they would often handle more significant issues which can often affect multiple workmen or entire establishment altogether. So after 1956, once this has been introduced, what happened is that a reference of dispute would be divided. Now, if disputes involving smaller issues or fewer than 100 workmen could be sent to the labor courts, and larger issues will come to the tribunal. So that was the position. Now, what is a national tribunals? Section 7B of IDA Act. It is constituted by the central government for disputes which involves questions of national importance. I'm sure you have heard about national green tribunals and all. For that is for questions involve protection of the environment. So like that, questions of national importance, there are national tribunals, and whenever there are these bigger questions, it is escalated to the national tribunal. The industry-wide strikes, disputes in a large central public sector company with nationwide operations, all those things are escalated to the national tribunal. Now, this Act, IDA Act, also speaks about in-house grievance redressal committees, which is Section 9C. Now, what is this concept, in-house grievance redressal committee? to resolve individual grievances within the enterprise rather than escalating everything to industrial dispute. This concept was brought in of redressal committees. There's a works committee, but that is more to reduce the friction between employers and workmen. What about individual grievances? So there was a grievance redressal committee. So every industrial establishment which employs 20 or more workmen will have one or more grievances redressal committees to resolve disputes arising out of individual grievances. So I'm sure if you're working at a place which has more than 20 workers, you would have seen that there is a grievance redressal committee, and their mandate is to resolve dispute arising out of individual grievances. Now, this committee is to consist of equal representative from the employer and employees, and for which the total number of members shall not exceed 6. So 3 plus 3 is a you'll see that makes sense. And if the committee has 2 members, one should be a woman, if practicable, because in some of the industries it would be like there won't be women, so then you can't do anything about it. But if it is practically possible to select a woman, you should. And if there are more members, women members should be included proportionately. So that also is about the composition of grievance redressal committee. And the chairpersonship of the committee is to alternate annually between employers representative and workmen's representative to ensure fairness. So I hope you understand this committee. It's a in-house grievance redressal committee. It has equal members of employers as well as workers, and there is also a small quota allocated for women workers if practicable. And the chairmanship of the committee will keep alternating annually between the employer's representative and the workman's representative. Now, what is the purpose of this committee? To provide quick and informal forum for individual employees to air their grievances. Now, employees would have a lot of problems, often individual problems. If it is a problem that has been taken up by the trade union, it becomes a collective demand. Yes, there are mechanisms to handle it. But what about individual grievances? Maybe a disciplinary proceeding that has been imposed upon you, which you feel is inferior. What about the work assignment that is given to you, which you think is unfair? You've been targeted and given more work in comparison with other workers. Now, these are all individual grievances. The service rule says that there can only be this many leaves, but you are not given that many leaves also, and your manager interprets the service order by saying that these number of leaves can only be given if you produce a health certificate. But that is not how you interpreted the service rule. So who to adjudicate this? So now, all for these reasons, there is a in-house grievance redressal committee. So how's the process of section? How's the process section? How does the entire process go on? So on receiving a written grievance from a workman, the committee should try to resolve within 45 days. Now, this is the 45 days that we have taken in the IR code for the resolution of non-public utility, industry related disputes. Now, within 45 days, there has to be a resolution. There has to be they should be able to resolve the grievance that is given by the workman. Now, this proceedings has to be kept simple and within the establishment. And just because there exists a grievance redressal committee does not extinguish the workers' right to approach a labor court or any other mechanism if not satisfied. Maybe the activity done by the manager or the employer falls under the purview of harassment, sexual harassment, or maybe under the purview of physical assault, or maybe under the purview of atrocities against minority community, or atrocity against physically handicapped person. So the person can escalate it to third parties. So just because there is a grievance redressal committee doesn't mean that the worker does not have the right to go outside. So you both can handle, both is possible. So there is a parallel case in the police station as well as in the grievance redressal committee. It is much possible. The intricacies of it we'll discuss in our final few classes, where we'll be discussing about how to conduct domestic inquiries and how to actually come to a conclusion, how to terminate and all. So that will, then you'll get a fair idea. But please do understand that this grievance redressal committees are never used to shield culprits, but it is just to provide the workers with an opportunity to resolve their grievances without going to a third person outside the industry. Now, what if the grievance redressal committee's decision is unfair, or let's say the worker felt unhappy or aggrieved by the committee's decision? What happens then? So he or she may still appeal to the employer within 1 month, and the employer shall appeal within 1 month. So both employer has, I didn't mean both employer, I mean the employer has the obligation to resolve the individual grievances of a worker. So worker goes to the grievance redressal committee and he is not happy with the decision. So if we are looking at the timelines, the worker went in, it's 45 days. He is not happy with the final outcome. He, within the next 1 month, within 30 days, he can appeal to the employer directly about the grievance redressal committee's decision being unsatisfactory. And the employer has to take a call on this appeal in the next 1 month. Now let's say the employer's decision also, the worker is not happy. In those cases, we have all this IDA machinery that I have explained. They can go to labor court, many other mechanisms. Now, Industrial Relation Code, what it has done specifically for in-house grievances redressal committee is that, imagine you are terminated. So that becomes a great thing, because a grievance redressal committee services is only available if you are a worker. What if the employer fire you totally? Then this in-house, because it's in-house, you have to be in the house, you have to be in the establishment to avail services of grievance redressal committee. So you're terminated, so you're not able to go to redressal committee. So what IR code have done is that now this committee has the power to resolve any dispute within 1 year of termination of employment. So anything that has happened in the place, even if you are currently not part of this establishment, you are currently terminated out of your employment, you can still reach out to the committee. Just that within 1 year you have to reach out to the committee. Now let's address the elephant in the room. How things have changed in the IR code, Industrial Relations Code. So as we've been discussing till now, the first thing that has been brought is that the law was kind of silent when it comes to non-public utility services. Any of the dispute, there was no time limit imposed. But the first time, this 45-day time limit has been introduced in the IR code. So any dispute has to be resolved within 45 days. Another change that has been brought is that I told you industrial tribunals were supposed to be a one-member mechanism, but now it will have two members. One would be judicial. I told you a high court judge equivalent person would be a tribunal a head, or would be the tribunal. Now we have increased it to two members, where there would be a judicial member as well as an administrative member. So the whole idea is that this widens the experience of the members, and now the decisions will not be made purely on the line of law, but also in terms of ground reality. Also, it may help in speed disposal of labor disputes also. So the mechanism to approach the tribunal has also been changed. So the concerned party may make application directly to the tribunal in the matters not settled by the conciliation officer within 90 days from the date of receipt of failure of conciliation by the party. So I told you this tri-party mechanism, the stepping stone is conciliation officer. And if you're not happy with the conciliation officer, you move to the tribunal. Now let's say you're not happy with the conciliation officer. A matter is not settled so it's not being happy with, but not being settled with the conciliation officer. Concerned party can reach to the tribunal within 90 days from the date of receipt of failure of conciliation. And appropriate government reference. That reference, discretionary reference, is no longer required. Now they can directly approach the tribunal. So what it does is that because now getting approval of the government, getting the reference of the government officials used to be a time-taking process, and there was delays which happened because of it. But now that you can directly go, just that within 90 days you have to. You can go directly to the tribunal. It will reduce the delays, hopefully, and it won't take much time to resolve the industrial dispute. So if you look at the IR code in a snapshot, we'll discuss the new 4 codes probably at the last sessions. But if you generally look at the general spirit of IR code, it has given weightage to the speedy resolutions of any sort of dispute. So that looks like a defining feature of IR code. With that note, let me conclude today's session. So we have in our past 2 sessions looked at various mechanisms that exist for resolving disputes at workplace. We have looked at mechanisms like conciliation officers, tribunals. We have looked at grievance redressal committees. We have looked at works committees. So that's the entire mechanism in front of you which you can approach in terms of industrial dispute. With that note, let me conclude today's session. In our next session, we'll discuss about this entire concept of giving notice before changing service conditions. So as I told you, standing orders or the service conditions are supposed to be very rigid, as in during the beginning of the employment contract, you have told that this is what is going to be your service conditions, and then you change it in between, there is some problem. It's kind of, it kind of violates the basic structure of employee employer relation. So there are provisions that the notices has to be given before certain days, and there are procedures to give notice. There are ways to bring in changes in the service conditions. So all that we will discuss in our next session, where we will discuss about notice before changing service conditions. So until then, let me take a break. You have a great day ahead. Thank you so much.